Our next speaker, David Meyer, has different training and a different perspective. He is an attorney who has specialized in mental health law and criminal defense for more than 30 years. He obtained his BA degree at the University of Southern California and his JD degree from the University of California, Los Angeles. Not stopping there, he's currently a candidate for the doctorate in health law and policy, emphasis on bioethics at the Loyola University of Chicago School of Law. He is currently a clinical professor and research scholar at the Institute of Psychiatry, Law, and Behavioral Sciences of the University of Southern California Keck School of Medicine. There, he is responsible for the criminal law and mental health curricula. He has a number of other accomplishments and honors, but we're going to stop there and have him speak to us. Thank you.
Good morning. Pleasure to be here, Ellen. I've been looking forward to this for a couple of years. We've been talking about it. I'm privileged to be on the internal board of the Sachs Institute, and oh, there's Jeff. This is one that I've been looking forward to for quite a while. There's a story here. As I was putting these slides together, I was also taking some photographs of our yard for my wife, who uses them in her business for a variety of purposes. And in pulling, you know how I have Macintosh, so you know how you pull around images? Well, I pulled it into the wrong place. And this photograph became, it's of my yard, it became part of the deck, and when I showed it to my wife, she said that I should leave it there because it would kind of lift up spirits. But it's cool, my yard, isn't it? Okay, so that's what it started out being. You'll notice that the scales are imbalanced. It's purposeful. We'll talk about that. This, by the way, for you lawyers, this is a session that gets full 45 minutes worth of CLEs, so pay attention. There will be a quiz. We're going to be talking about something that works. There's much frustration, of course, among all of us and amongst all of those who work in our areas with regard to individuals defaulting into the criminal justice system who happen to have a mental illness, and they are in all of the above categories that Dr. Southard addressed. In fact, it's true that across the entire country, and including here in Los Angeles, individuals who cannot be otherwise served end up being the focus of attention of law enforcement and ultimately of prosecution and the courts, and for a variety of reasons, that's a bad idea. So let me talk a little bit about objectives for this morning. I'm going to describe mental health courts and how their operations work. We'll talk a little bit about outcomes. I'm going to identify some anomalies regarding mental health courts and some differences that are very problematic in terms of the justice system at large. So you lawyers, this is a challenge for you in terms of where you want your system to go. We're going to observe some ethical issues that inure to processes and practices in criminal courts. So Chris, where's Chris? Thanks for turning this on, and we ought to apply for some ethics credits from the State Bar for this as well, because we are going to be talking about ethics. And we're going to be talking about boundary issues. As we'll see in a moment, mental health courts are teams of professionals who interact and work together. They don't much observe the traditional boundaries of professional practice. And that, again, is a problem, both a practice problem in terms of licensure and an ethical problem for all of the people who work in these courts. And we're going to propose some resolutions. I'm doing research on preparing a dissertation on this very thing, so your feedback is important to me. I hope we have plenty of questions, and as we go through the day, I'm anxious to hear your comments and criticisms. Welcome to my bias. I'm a lawyer. I'm absolutely convinced that mental health courts are among the answers to the defaulting of people who have mental illness into the criminal justice system. I bring to this a lawyer's perspective. As Dr. Mayberg pointed out to me last night, if you peel away layers of the onion, increasingly what you're going to find down there is a public defender, which I was for 25 years. So I come to it with that bias. And what I'm trying to do is find a way for mental health courts to work within the context of the criminal justice system and the legal system at large. Now, you know, you're all experienced to a greater extent with courts and the justice process, the trial process, even if it's simply from watching Judge Judy, or perhaps, I know there's some judges here today, certainly some lawyers, you all know how it works. What you do in a traditional adversary court is you bang heads and you argue, and there's lots of conflict, and opposition is the way you attempt to come to resolutions of problems. The traditional court also works with a binary set of processes. That is, everything in the criminal justice system is an either-or proposition. Guilty, not guilty. Objection overruled, objection sustained. Motion granted, motion denied. Guilty, not guilty, that sort of thing. It's an either-or binary sort of process that fails to have intermediate kinds of mechanisms for resolution. We're constrained by historical rules that may have made sense in the 18th century. Really, we observed the hearsay rule as if it was meaningful. In fact, there are so many exceptions to the hearsay rule that it doesn't really exist at all, but we love to talk about it in the legal community. Really, many of these rules have no real meaning in the modern world. The judicial role is passive in traditional courts. One of the principal roles of judges is to be referees. Now, that's not always true in bankruptcy courts and probate courts. Judges are much more involved, much more active in the process, but by and large, judges are passive in the process. And we have very limited outcomes potential. People found not guilty by reason of insanity are never released, although they could be, by the way. They are always committed subsequent to the finding of not guilty by reason of insanity for a period that's equivalent to the maximum sentence they could have served, and where they go is a state hospital, which in this day and age is not out on a green somewhere with people playing bocce ball. It is a place with barbed wire around it and guard towers. State hospitals have very much changed. So, why do we need to change this? Why do we need to think differently? Well, it's simple. It doesn't work. Einstein had the correct definition of insanity. We in the legal community do not. But Einstein said insanity is repeating the same process over and over with the expectation that you'll get a different result. You won't. We keep doing the same thing. We have for the last 250 years done the same thing with respect to individuals in the criminal justice system who have mental illness, and it doesn't work. Adversary justice simply doesn't have the subtlety to be able to deal with very individualized and very sophisticated kinds of life problems that individuals who get caught up in the system deal with. And so I quite agree with Dr. Southard that there is some component of folks in the criminal justice system who are simply evil. I get that. I worked with them for 25 years and knew a lot of them very well. So I understand that and I accept it. On the other hand, what happens in the real world at this point in history is that individuals who have serious persistent mental illness, who get themselves in trouble out in our community, most often come to the attention of 9/11 response, law enforcement, or the fire department response to these things more often than anything else. Institutional treatment does not work. Sorry, I don't agree with you about state hospitals. I'll take you on if that's necessary. I don't think there's any relationship between the reduction in state hospital population, which was in the 1960s mainly civil committees and a minor number of forensic patients, and the increase of the number of people in that come to the attention of law enforcement now. Cost, we couldn't do it a more expensive way. And the evidence shows us this. I'm not going to dig too deeply into outcomes and evidence on this subject, because we got the great guru of this area, Dr. Hank Stedman, who's going to follow me, and he's a lot smarter than I am anyway, but he certainly knows a lot more about it. I will say that in his question and answer period, though, I'm going to be carefully cross-examining him about the latest study on which he is a co-author, with which I'm troubled about outcomes in mental health courts. Not to say that he hasn't written 10 times that number at least, in which he's the principal investigator, where we have very supportive evidence for outcomes in mental health courts. There you go. Enough said by me on this subject. I will say, however, that to me, one of the principal outcomes that I find positive with respect to mental health courts is the level at which these courts can link into services in the community. And I'm going to avoid the word care or mental health care or treatment today, because the services that are available to people are far broader than those components of services. And things like housing are immensely important to individuals' success in the community, and that's not really a form of treatment. People are a lot happier when they have these kinds of outcomes and get their lives back and get relinked into the community. And non-custodial housing is not only better housing, it's cheaper housing. You can't do anything much more expensive than put somebody in a state hospital. I don't know what it is. I don't know. If you've been in a hospital, I hope you haven't been in a hospital lately. If you have, it's probably costed between $1,000 and $2,000 a day. Those are real costs. In the mental health system, we don't look at the universality of the costs, and so the costs seem to be a little less. But the last time I was aware of it was about $500 a day for a state hospital bed. It's upwards of that, no, Steve? $185,000 a year to keep somebody in a state hospital. Hello. Okay, let's talk a little bit about the history of mental health courts. This is an iteration of what is called problem-solving courts. It began in Florida in the Dade County area with drug courts, something about which I suspect all of you have heard. This is the offspring of drug courts and other problem-solving courts. We call them, for reasons that I find unjustifiable, in California, collaborative courts, but that's what the Judicial Council calls it. So you'll be hearing me refer to collaborative courts as well. It's a drug court model. Ginger Lerner Wren, my friend, Steve Mayberg's friend, never gets credit for creating this. So I always give Ginger credit for creating it. Broward County, Florida, Hollywood, Florida. The Department of Justice has heavily supported the development of mental health courts, as has something called the Consensus Project, which is a fully funded project of the Council on State Governments. These two sources are very rich sources if you are interested in learning more about mental health courts. My friend Mike Tynan, who is a judge in a reentry court and a mental health court up the street in the Fultz building, says that the mental health courts are losing their identity to other names. And what he means by that is simply that his homeless court and his veterans court, he also has a reentry court, are really and truly mental health courts because of the overlay of mental illness and these other situations. So you'll find mental health courts in places that are named other things. Some commonalities of mental health courts. They make decisions, they make plans, in teams, collectively, collaboratively. They use consensus building, and very often decisions are made on a consensus basis. They can talk themselves on and on and on for hours about issues, rather than the judge simply saying guilty or not guilty. That's my impression. It's a team effort. It involves clinicians, it involves lawyers, mental health professionals, the judges, all kinds of people get involved. Screening and assessment is done very early in the process. I say that and observe that because it's one of the things that distorts the criminal justice process. I'll mention that again in a moment. It's a diversion from the traditional criminal justice process. I am queasy about the word diversion because really it's an inclusion of things into the criminal court process rather than a diversion from something. There's an emphasis on problem solving. That's the objective. These are not fact-finding courts. When you go into a criminal court, you have either pleaded guilty or you have given up your right to a speedy trial and a speedy resolution of the charges against you. You're in it, and there's no fact-finding. If the evidence obtained against you was illegally seized, you're not going to get it suppressed. You're going to go into a mental health court situation very early, and the rest of the criminal justice process is not going to be served. There is a focus on continuity of care and a variety of services that are dependent on the assessment of the individual's needs. And so while in a regular criminal court, what you'll see is basically a probation officer, perhaps a lawyer, perhaps not, following an individual over a long period of time, particularly with a particular focus on antisocial behavior. In a mental health court, what you're going to find is all sorts of folks, depending on what the individual needs are. They might be clinicians. They certainly will be lawyers because people continue to be represented. They might be housing specialists. They might be any number of things that will aid an individual in achieving their life goals. And that indeed is a primary focus of the mental health court, setting goals for individuals. A strong focus on supervision. There's another word I don't like. There's really a strong focus on case management is the way these things operate. The defendant's understanding that the focus is going to be on what happens in their life and the progress in their life is key to it. It is voluntary. I'm going to make more comments about that in a moment. I know there's controversy about that, and I expect to hear some questions about it, which is fine. There are multiple rewards and sanctions that are utilized in a mental health court. They're very different, however, than the traditional notion of sanctions, at least. You don't find many rewards in a criminal court, in a traditional criminal court. There are very heavy sanctions, and again, they're delivered in a binary fashion. Go to jail for X number of days, go to state prison for X number of years, that sort of thing. But the rewards and sanctions in mental health courts are much more subtle. There can be rewards, there are rewards for achievement. Sometimes it's a ticket to a movie. Sometimes it's transportation. If you go to Judge Manley's court up in Santa Clara County in San Jose, you'll find a large kind of fish bowl right on his bench that is filled with a variety of crumpled up papers. And when he wants to reward someone, in some cases, he will invite them up to the bench. As you know, as you lawyers know, that area between counsel table and the bench is never land. You never trot in there. But Judge Manley intentionally brings people into that area to approach his bench. They reach into his fishbowl and pull something out. And when they open up the crumpled paper, they'll find a reward. Maybe it's dinner at a restaurant. Some other kind of entertainment. Looks almost like a game show when he does it. But it's very different, and it is, you know. We all like getting little rewards, and individuals who succeed like getting little rewards, and it's a big deal. He also hands out little sanctions, as is true in all mental health courts. And these little sanctions may be, if it's really something very serious, it may be a day in jail or a weekend in jail. It's really kind of a time out for the individual. They may have fallen off the wagon. They may be using substances or whatever, and they simply need to get away from their immediate circumstances for a brief period of time until the housing folks can get them into more permanent housing, and he puts them in jail. That's considered a sanction. Judge Lindley, who's down the freeway here in Santa Ana, will assign people essays. You have to write an essay as a sanction. Now, this is something that is significant. Many of these folks are not used to writing essays, have not had any real training in doing that, and it's a hard thing. But not only do they write essays as a sanction. They present their perspectives in the court to the judge, who then interacts with them and discusses what they're writing about with them. Serious stuff, an essay, and it's an achievement when it is done. There's a focus on restorative justice and victims in many of these courts. That's something that's pretty much left out of the normal criminal justice process. The victim in a crime is, in most places, all but irrelevant. Not in many of the mental health courts. Now, I've added this one in yellow. That's the others are from a publication by BJA, Bureau of Justice Assistance, which is cited. This one is something that I've observed, but with which I think most folks who are familiar with mental health courts will agree, and that is that the focus of the players is on recovery. It's not a focus on symptoms. It's not a focus on medication taking. It's not a focus on life failure. It's a focus on life achievement and long-term stability and long-term growth as a human being. That's the way folks in these teams and the judges think. It has to be observed that there is no single template for a mental health court. There are as many different approaches and different processes as there are mental health courts. There are no two the same. They have commonalities, as I've mentioned. It must also be said that the successful mental health courts, and in this context I mean successful by the ones that have lasted, they haven't all lasted, but the ones who've been here for a long time and will continue to be here are very much driven by the personalities of the individuals who are involved. Remove the personalities and the thing doesn't work. There isn't a template that they can work off of. This is especially true for the judges. Hank and I were discussing last night our mutual friend, Judge Stephen Manley in San Jose. And Steve is unlike any other person in the world. He's unlike any other judge in the world. I don't know how his court could operate without him, although he frequently has other judges cover him. But he's just a very unique individual. He's very involved. He cares very, very deeply about the individuals who are in his courts. And he's just a remarkable human being, as is Judge Wendy Lindley, just down the freeway here. If you want to go look at a mental health court, there's one quite available to you. Just down the freeway, go down the 5 to Main Street, get off, and go from there to 9th Street. 909 Main Street is an Orange County Community Court. Judge Lindley operates several mental courts, actually. It's an interesting place to learn about mental health courts because it's unlike other courthouses. You go into Judge Lindley's courthouse and you do not see the doors of courtrooms first. In fact, you don't really see much that looks like a courtroom at first. What you see is offices for the various agencies that work in the teams. Orange County Health Department, Social Services, Veterans Administration, even from different governments, are officed right there. In front of the courthouse, there's a sign that says, "Welcome to your community court." And actually, people do walk in off the street, especially people who are seeking services. So if it's a veteran or an individual who has been getting services from Orange County Mental Health, Behavioral Health Division, they can just walk into the courthouse and go to the little office there that's run by that agency and get services or get linked to services. Judge Lindley, of course, has those individuals available directly to her in the processing of cases in her mental health court. Here's some legal sacred cows. These are the things I was talking about that are going to disturb traditionalists in the legal system. These things do not reflect equal justice. Some people get into them and are greatly benefited by them, and some people don't and don't have that advantage. There simply is not equal access to these things. In Los Angeles County, we really don't have an adult mental health court. We do have actually more than one juvenile mental health court. I know Judge LaVenter is here from the juvenile court. Are you here, Judge? I don't see him. But there is a large juvenile mental health court at our Eastlake facility. This is right near the medical school. There are smaller iterations of that in other places of Los Angeles County, but no broad-based mental health court here in Los Angeles County. The answer to why is intriguing. Lawyers who have innocent clients get really upset about these courts because there's no fact-finding process. If you want your client in a mental health court with the advantages that a mental health court provides, you are not going to get a trial. You're not going to suppress evidence. There are people who claim they are not guilty, who are in mental health courts in any event, and who will either suffer some of the effects of a guilty plea or all of the effects of it. Counseling becomes a very squishy word with dotted lines around it for the individuals who work in these courts. Lawyers are put into positions that with which they're not comfortable and for which they've not been trained. One of the big deficits in mental health courts is there is no training for lawyers in these approaches to justice. Lawyers go into these courts without experience, without knowledge of how to operate in them. Law schools don't teach this stuff. For that matter, most of our medical schools and graduate schools don't teach it either. There is a significant question as to whether or not people participate voluntarily in mental health courts. Indeed, they sign consents and a variety of waivers, and indeed their lawyers explain to them that they're not going to get trials and not going to get an opportunity to contest the allegations. And indeed, they do say yes. The question is that the equivalent of voluntary? First, in the sense that you clinicians understand the concept of informed consent. There are some questions about whether or not these consents are valid. And in addition, many folks argue that this is not truly voluntary. It's merely an expression of a Hobson's choice. You have bad choices, and this is the least bad of them. So that's why you volunteer. Clinical sacred cows as well, and a lot of boundary jumping. We were discussing last night some of these issues. You see defense lawyers arguing for additional sanctions, prosecutors arguing for a lighter touch. You see non-physicians putting in their 2 cents about medication selection. Things get all mixed up in here, and they can get pretty confusing. And indeed, it's one of the reasons that I'm so interested in this area. Murphy's Law abides in the justice system, and sooner or later, someone will feel aggrieved by having participated in the system. It'll happen in a very high visibility case, a death penalty case or something of that nature. There has already been expressions from a variety of places in terms of lawsuits. Very interesting lawsuit by the district attorney of Maricopa County, Arizona, against the judges of Maricopa County, accusing them of undermining the criminal justice system with specialty courts, such as mental health courts and drug courts and things of that nature. The district judge in the Ninth Circuit ducked the question and found that the DA didn't have standing, but there it was. Okay. Is there time for questions?
Mr. Meyer?
You're on. You got it.
Okay, I'm not a lawyer. I got a bachelor's degree in business administration. But I know it's one thing about the criminal justice system is that there are more African Americans in the criminal justice system that are going to college, or graduate school, or professional school. My question to you is that a lot of the African American detainees, do they have the choice to go to, if they have mental health issue, to go to a mental health court and avoid the ordinary criminal justice proceeding in a criminal court?
Good question. The question is, and essentially, is selection into mental health court even-handed with respect to African Americans and I suppose any peoples of color or any minorities? And the answer is there are no good data on that. I don't know. It's no secret. We're not hiding things from one another. In the criminal justice at large, there's a giant overrepresentation of African American people and peoples of color. We know that. That's no secret. Whether or not within that population individuals are being deselected based on race, I haven't seen any good data on. Maybe, okay, well, Dr. Stedman has, he'll answer your question. I can tell you this. There is an overrepresentation of African Americans in certain kinds of crimes. And there is also a set of selection criteria in each of these courts, some of which deselect those same crimes. So if an individual is, for example, charged with sales of crack or possession for sale, a large amount, they may well, which is a crime where there's an overrepresentation of African Americans. If they are also ineligible for mental health court because of that crime, and selection criteria for the courts sometimes do that sort of thing, then the answer would be yes. Now, I don't know the data. We'll ask Dr. Stedman to elucidate.
Hi. My name is Nomi Lanki, and I'm with
Hi,
NAMI
Zoe.
Orange County, and I want to share firsthand, if I just wanted to make a quick comment on Judge Lindley's court, because NAMI Orange County actually has an office in her court. And where this works the best is because we are there versus them just handing people a flyer about this to go out and find this community resource. At the end of each court session, Judge Lindley says, now go and report to the NAMI Orange County office, where they come in and we engage the clients into our programs. I cannot even begin to tell you how successful it has been. We have had clients coming from the court through our peer-to-peer and family-to-family programs, and some of them now are actually working and have said that this has saved their lives because they are now learning about their mental illness and how to take care of themselves.
Very broad range of services directly available to folks who access that court, and to Judge Lindley, who says, oh, well, we've decided in group here that this is a necessary support service for an individual. Somebody go out in the hall and get them. That happens.
And that's the key, because if they just handed them a brochure to call us, or she never even mentioned who we were, they would have never come our path. And just real quickly, if you can't get down the freeway to the Judge Lindley, we do have on our NAMI Orange County website, it's namioc.org. If you go to Outreach, video presentations, there's a short video clip of Judge Lindley actually leading one of her veterans courts. And it really is great to see. It's very short. And again, it's at namioc.org. Go under Outreach, Video Presentations, and click on Veterans Court, and you could get to see her without having to drive there.
One of the dangers to courts is really to these courts is a professional sort of danger. I've spoken with both Judge Tynan and Judge Lindley about this, but the California Commission on Judicial Performance, which is the body that disciplines judges, has expressed interest in mental health courts at the level of asking questions like, well, why are judges hugging individuals in the court? Now, this is a very common thing to do. Happens in Judge Lindley's court, and it's a worthwhile experience, I should think. Happens in Judge Tynan's court and Judge Manley's court as well. But the Commission on Judicial Performance doesn't like judges behaving like that, so it's a real danger.
Hi, my name is Sawako. I'm the coalition member. And my question is there psychotic ward for life in prison?
Well, I'm having difficulty understanding, so just get a little closer to the microphone.
Okay. Is there a psychotic ward for life in prison for mass shooter like Colorado Theater?
Well, it's a big question. Is there a special mental health ward for individuals who commit these terrible sorts of acts as we've seen recently on television? They're very high security areas within every jail, and generally speaking, individuals, whatever their health, are held in those wards.
Hello, I have a question. In Los Angeles, there's a program called MIST, Misdemeanor Incompetent to Stand Trial.
Yes.
And if you have a misdemeanor offense and a doubt is declared about your competency, then the criminal proceedings are put on hold and you are given treatment to try to restore your competency. The problem is if you don't get restored, you end up serving the maximum time for this offense for something like taking a shopping cart, where otherwise you go to court and maybe they give you time served because you're in jail for 3 or 4 days.
Your observation is accurate, but the causation is not. It is true that individuals who have serious persistent mental illness statistically spend more time in custody in the Los Angeles County Jail and everywhere. That is true. But it is not a consequence of the MIST program, which is actually an effort on Los Angeles County's part to shorten the length of time that individuals are subject to custodial treatment. Those individuals have been found incompetent to stand trial. They may be held for as long as their sentence while they're recovering. If it's a state hospital to which they go, there's going to be an even greater problem. It'll be longer. So the effort that Los Angeles County has made is to shorten the amount of time that it takes the person to get through the restoration process, get back to court, and get going.
Let's do one more. Sure. Thank you. My name is Maureen Mina. I work up in Santa Barbara at the County Mental Health Department. And you mentioned recovery. And
How's Jim?
Pardon me?
How's Jim?
Jim.
Broderick?
Oh, Jim Broderick.
He's gone, huh?
Yeah, no longer with the department.
Shows you how old I am.
Yeah. He was a good guy, though.
He was.
Anyway, you mentioned recovery and how important that is to look past the person, past their symptoms and past their illnesses. I'm wondering if you've had any experience with people who are working at restorative court as a member of the team and what role they play.
I missed the critical part of your question. Have I had any experience with what?
With people who actually have recovered and are serving as part of the team of the
Sure.
mental court.
Most of the more sophisticated courts, at least, that I'm aware of, have included consumers in their programs. One more, she swears.
I promise.
We won't abide it.
I promise it'll be worth it. My name is Jennifer Hoff. My son Matthew is in isolation right now in Orange County courts. He's going to serve about 11 years for walking into a Bank of America with a sticky note demanding $1,000. So he's going to spend the next 11 years in prison. We know all about the mushy language that you were describing when it comes to people who might not be voluntary or want to access the wonderful services that Lindley's Court has. So I'm curious to know what is happening out there in the legal world with regards to tightening up this mushy language, the gray zones between, we know the son is sick, he has crazy tattooed on his forehead, but he says no to help. So they go to prison and rot. So we know things like this are happening. There's a population that isn't getting the help they need. But families like us just aren't seeing the legal guidance trying to fix part of these problems.
Yeah.
It's
Gosh,
kind
I
of,
wish
yeah.
I was smart enough to know the answer to that. I'm not. I defy folks who say that there are. It's a desperately complicated and difficult set of issues, and it boils down to how much, in terms of public health, how much we are willing as a community, how much we're willing as a government to reach into people's lives and force them to do things that they are expressing resistance to. So, I mean, there's some civil rights lawyers among us, there's some constitutional lawyers among us. We'll get into a raging debate about that. I don't know the answer. I completely join you in observing the problem.
Okay, thank you.